Thank you all. That was an informative session, and I will highlight its title. Corporate calm is not the absence of uncertainty, but the ability to manage it with confidence. And now, ladies and gentlemen, we enter the final segment of today's program. We do with a broader perspective, one shaped by a full day of dialogue on governance, predictability, investment, and trust. We now turn to a conversation that examines how trust is formed and tested across cultures and legal systems. Building Trust Across Cultures is the title of our next session. Trust is the invisible infrastructure of the global legal system. It is shaped not only by laws and rules, but by culture, history, trust, and the values that guide decision making. So now please join me in welcoming our esteemed panelist and the moderator for this panel. Hello and welcome.
Which is good.
Your Highnesses, Excellencies, expert panelists, and dear friends of UNCITRAL, as well as guests and distinguished participants, good afternoon. My name is Neil Bergman, and I am a senior legal officer at the UNCITRAL Secretariat, and it is my honor to moderate Panel 5 with such distinguished experts. This panel will examine the building of trust across cultures and examine how cultural differences in governance and legal systems affect dispute resolution. Over nearly 60 years, as we've heard throughout the day, UNCITRAL has demonstrated that its inclusive, consensus-based working methods, bringing together representatives and other stakeholders from all regions of the globe, economic systems, and legal traditions, result in instruments that reflect this diversity, helping to ensure legitimacy and acceptance and to build trust across cultures. I am eager to hear from our expert panelists with whom I am honored to share the stage. We are joined by Ms. Blair, the founder and chair of Omnia Strategy, Professor Chang, the Secretary General of the International Organization for Mediation, His Excellency Dr. Sepelek, the Secretary General of the Permanent Court of Arbitration, and Professor Dr. Eigen, the founder and former chairman of Transparency International. To begin our discussion, I would invite each expert, in that order, to offer their opening remarks on how, from their experience and perspective, cultural differences in governance and legal systems affect dispute resolution. Ms. Blair, please.
Well, it was 10 years ago, nearly, that I was in Delhi celebrating the 50th anniversary of UNCITRAL. And at that time, I was anticipating where the global legal order was going in the face of attacks on globalization, a new president in the White House who seemed less keen on globalization, and a feeling among states, including in Europe, that investor-state dispute resolution was actually anti-state. And now, 10 years on, pausing to reflect, things haven't actually changed and the pressures on the international legal order have intensified. We see a backlash against globalization. We have President Trump in his second term in the White House and deepening geopolitical tension. And that in turn has led to renewed skepticism about international institutions. I was in Davos this year and was there when Canada's Prime Minister Mark Carney warned of the dangerous drift towards a world in which might is right, and in an increasingly multipolar environment, the conduct of dominant actors has too often weakened rather than reinforced the idea of this overarching code of international law and conduct. And this matters profoundly because ultimately a rules-based international order rests on consent and participation. And it only works if those with the power to ignore it instead choose to uphold it. And that's why international investment arbitration lies at the heart of rules-based order. Why? Because almost uniquely among the international law, it has teeth. Because its awards aren't just declaratory, they are enforceable across borders, against states, through the domestic courts around the world. And it's that enforceability which transforms legal obligation into real-world consequence and voluntary consent into actually meaningful restraint. And it's precisely because international arbitration has teeth that it has attracted sustained scrutiny. Because when arbitral awards are enforceable across borders, they do more than just resolve disputes. They affect real regulatory choices and shape public policy. And so it's not surprising, is it, that states and public opinion have begun to ask a difficult but legitimate question. Why should foreign investors be so uniquely protected? And at heart, that question is about trust. Because trust has to be the foundation of any system that operates across borders and cultures. But we can't just assume trust. It has to be earned. It depends on whether the system is perceived as fair, as responsive, and as capable of operating across different legal traditions and social expectations. And it's why initiatives like UNCITRAL's rules on transparency in investor-state arbitration and the Mauritius Convention represent an important step forward in earning that public trust. Now, one of arbitration's great strengths is its capacity to sustain trust across borders and cultural difference. Through party autonomy, arbitration allows parties to shape procedures that reflect their legal traditions, their commercial expectations, and the ways of doing business, in the choice of arbitrators, in the language of the proceedings, or in the way in which the hearings are conducted. And that flexibility doesn't weaken the rule of law, it actually strengthens it. Because when an international system acknowledges difference rather than insisting on rigid uniformity, it's far more likely to command legitimacy and acceptance across a plurality of cultures. And in today's increasingly multipolar world, that sensitivity is not a luxury, it is essential for trust. And I think we can see that most clearly in two areas that test the credibility of international investment law: human rights and climate change. We have the human rights framework to protect fundamental human interests across cultures. And there is growing momentum for international investment law to take those interests seriously. Take, for example, the Bangladesh Accord, the first legally binding agreement between global brands and trade unions with a dispute settlement before the Permanent Court of Arbitration. Sadly, as you pointed out to me, it was settled, so we will never know how arbitration might have dealt with that dispute. But also we're seeing human rights considerations shaping investment arbitration through arguments advanced through parties, through the way the tribunals interpret their obligations, and procedural innovations like the Hague Rules on business and human rights arbitration. This evolution enhances transparency and legitimacy and recognizes the public interest character of disputes involving serious human rights impacts. And make no mistake, investor-state disputes do involve human rights impacts, and we ignore them at our peril. The same is true to climate change and environmental protection. If international arbitration is to retain trust, it can't say these are external or peripheral issues. Investment law does not operate in isolation. It has to be interpreted in harmony with states' international commitments. And that, in fact, was something that was made very clear recently in the ICJ's ruling on the climate change litigation. I was privileged to represent Albania in that arbitration, and we stress that investment tribunals cannot just say climate change obligations are mere background context. They are integral parts of international law, and their significance doesn't diminish simply because a dispute arises in investment fora rather than elsewhere. And the court said as much in its judgment, reinforcing the need for tribunals to interpret investment protections consistently with the state's environmental and climate operations. They are part of an overriding body of international obligations that are owed. So I think 10 years on, there is room for cautious optimism, but the legitimacy of international arbitration will depend on whether it's seen as fair, responsible, and capable of addressing across cultures the realities of the world in which it operates. And trust will only endure if arbitration continues to adapt and demonstrate that the rules-based system serves people and not just parties.
Thank you so much. Thank you so much, Ms. Blair. Secretary General Chang,
Thank
please.
you. Thank you very much. The existence right now of all the turbulent and uncertain times, I think it's a well-known predicament that we're all facing. And therefore, the theme of this week, finding a predictable dispute resolution for these uncertain times, is particularly relevant. I would like to think it's not just predictable dispute resolution process, but also predictable outcome. And I think that is something that we must all, or the parties, would be looking at. And this sort of discussions, in a way, really bring out the importance of building trust, maintaining dialogue, and be inclusive in the process design in how the dispute resolution is to be conducted. So what I will do is I will focus on mediation, representing the International Organization for Mediation, so I will just focus on that. But before I do that, I'd like also to take this opportunity perhaps to demean the point that I heard has been raised a number of times even this week, and that is mediation and conciliation different? I would like you all to think about mediation and conciliation is the same thing, whereby a third-party neutral is involved in facilitating the discussions between the parties and in offering, if at all, an opinion which is non-binding but really helps the parties to settle. And this proposition of mine doesn't come from me. It came from UNCITRAL back in the 1980s. It came from the Chartered Institute of Arbitrators back in the 1990s, I think. And so let's not split hair about conciliation and mediation, but look at the process and the rules that's being done. So that's where I would begin. Now, when I talk about mediation, and bearing in mind the theme of this particular session, mediation is premised on trust, or the success of mediation is premised on trust. And yet, mediation also rebuilds trust. And I think this is the beauty of mediation when we look at the concept of trust coming in. The fundamental quality of mediation is that of voluntariness, and that is, of course, a key to success. That voluntariness brings out 2 points, namely the control of the parties of the process and of the outcome. And this goes back to the predictability of the process itself and the outcome, something that I think parties themselves would always like to achieve. The flexibility of the mediation process, because if you look at any rules, most of the rules on mediation will tell you there is actually no rule. You design the process to cater for the particular dispute. You design the process to cater for the legal traditions, and of course also the personalities and cultures involved. So the process design, the negotiation skills, and the ability to appreciate the perspectives from the other side, and indeed from all sides, becomes a very important core features to the success of mediation. These, however, are manifested in different ways, primarily as a result of the difference in cultures in general, but also of the legal traditions and sometimes of the way people approach certain matters by way of the cultural background they're coming from. Now, it's interesting to observe, again, something this week I picked up, that in fact, apart from Asia, where I'm coming from, African states, where some of our member states are, and also the Islamic states, all have a culture of mediation, as it were, in their blood, in their DNA. And I then start to think, whilst these are the common features of some of these groups and regions, yet there are still a lot of cultures that are different, cultural differences. How would these cultural differences be addressed in order to enable trust to be rebuilt or trust to be used for a successful mediation? And in answer to that, I'd like to look at 3 things in the context of mediation. 1, the framework. 2nd, the mediators. And thirdly, between the parties. And I leave the 4th one as a question, and that is the trust within the party itself. So let me look at the framework. And when we look at the framework, I'd like to remind you all the work that, in fact, UNCITRAL has done a long, long time ago. We all understand the UNCITRAL arbitration rules, the model law on arbitration, 1976, 1985. But in fact, the UNCITRAL conciliation rules was first promulgated in 1980. It was then modified or updated into the mediation rules in 2021. The model law on mediation, 2002, updated in 2018. The Singapore Convention on Mediation, concluded in 2018, came into force in 2020. And in 2023, the ISDS Working Group 3 reform, looking specifically on guidelines on mediation and international investment disputes, and also on model provisions for use in ISDS matters. And then I'd love also to share with you, in 2025, the International Organization for Mediation was established. So you can see the thrust of the development of mediation, in particular under the auspices of the instruments that were promulgated by UNCITRAL, came out round about 8 to 10 years from today, working backwards. And I think that momentum is quite significant to bear in mind the needs and the wishes of the parties who are involved, in particular in investor-state types of disputes. So if I'm to look then at the framework with the UNCITRAL background in mind, I'd like to share with you some other aspects in the commercial and investment mediation rules that the IOMAT has promulgated, which also reflects the inclusivity of our rules in this way. For example, instead of just having a sole mediator, we called it a mediation commission because we would expect possibly cross-border different cultures, and each party may wish to have someone who understands their culture. That was actually something that the states, when we discussed, wanted that because they'd like their cultures and their specific legal traditions to be taken on board. There is another factor that is also interesting. Instead of just allowing for already a mediation clause for those disputes to come. The states themselves wanted, the experts from the states wanted a provision to allow an oral mediation agreement to come to the IOMAD and then convert it into written through certain forms and certain rules that we have. And we also actually cater for a situation where parties offer to mediate, where the IOMAD would try and encourage the other side to accept the offer to mediate. Now, these actually come from the wishes of the parties who really, or the wishes of the states who really want mediation to take off, and it shows a reflection on the culture or perhaps the need of encouraging mediation to be used. The second aspect of building trust, having talked about the framework itself, is of course the mediators. Now, again, using, and I think that would be the same with other bodies, but I use the IOMAD as an example. The mediators, of course, like everybody, can be chosen by the parties, and that's inherently something that they would trust, a person they would trust. But short of that, and if they don't know where to go for, they would go for the people on the panel of mediators. And the panel come from two sources, one from the rectifying states, of which we now have 11, and the other coming from the governing council, who will have a list of mediators who would come from internationally well-renowned, irrespective of their nationality. So the trust on the mediators by the parties can only be enhanced by the solid and concrete and credible panels that the bodies manage. And I think that's very important. And that is something that all of us will want, who believe in mediation, who want to continue to encourage training and updating of skills for the mediators. Now then I turn to the third one, trust between the parties. Trust between the parties is extremely important, but usually not at the start of the mediation. I would use the example of a mandatory mediation clause. Parties are forced to go to the negotiating table, but they may not even want to see each other. So I had the benefit of one such mediation. Both sides call me up and say, I'm not going to the negotiating table, I'll just run through the process. So the whole mediation was conducted through a series of caucuses until both of them agreed to sign on a settlement agreement, and they then have the first joint meeting and of course lived happily thereafter. So this is sort of like sometimes by the mandatory mediation, the mediator can still help the parties to rebuild trust. And there are, of course, other skills that the mediators may use. It's like closing a deal, restructuring a debt, and all these are very important. And it still, therefore, goes back to the other thing that the IOMAD does, and that is capacity building. Capacity building in getting the mediators ready, but also capacity building in getting the parties ready. So I stop here, but I leave the question, what about trust within the party? For example, if it is a state, how do we ensure that within the state, the trust is there to allow whoever is at the negotiating table to conduct an efficient and effective and fair mediation process? Thank you.
Thank you so much, Secretary General Cheng. And now, Secretary General Sepelek, you have the floor, please.
I would like to start by expressing my gratefulness to the organizers for inviting me to this panel. I'm delighted to be in Riyadh, not for the first time and hopefully not for the last time. I think we all agree in this room that dispute resolution is based on trust. Now, the question is how you can trust a person whom you don't know, and how you can know a person whom you have never met. In 1899, 26 states met in The Hague in order, or in the search for a new multilateral order, in the search for a solution which would respond to geopolitical crisis, which now we know it, in 15 years, it led to a First World War. They created the first multilateral mechanism, the first international court, the first international institution with the mission of solving disputes. What was the founding moment of the establishment of the Permanent Court of Arbitration? It was the principle, at the time disputed and debated, that all parties are equal, or states who are sovereign are equal. Probably this debate continues politically, legally, but at least for the PCA, between the first and the second Hague Peace Conference in 1907, it has been solved. All PCA contracting parties are equal, and the change from 26 states in 1899 to 43 in 1907 was a testimony that it was a good choice. So if you enter the Peace Palace, you will see there is only one administrative council for the Permanent Court of Arbitration, composed of the ambassadors of all contracting parties, and there is only one chamber. There are two great and small halls of justice on the side, on the ground floor, and in the center, one chamber. There is no group of equal states and another group of those who are more equal. What I'm saying about it, and you know that PCA as a very old institution had its ups and downs, but throughout the whole history, this principle of equality of states, of their legal traditions and legal cultures, has been a reinvigorating principle, which led also in the last 2 years to new wave of accessions. Vanuatu, Timor-Leste, Armenia, Moldova, and on Monday, Indonesia became our 127th contracting party, and yesterday, so on Tuesday, literally before I caught the plane to Riyadh, I was witnessing the accession ceremony of Botswana as our 128th contracting party. 6 new accessions, based on this principle that everyone is respected. There is no trust without respect. It's entry point. We don't speak about trust if we don't respectfully address each other. So this principle is equally valid for the Administrative Council as for another organ of the PCA, the International Bureau, headed by the Secretary General, so currently by me. How we live this principle, how we reflect cultural differences. We are a small organization, a bit less than 100 people, but we represent 43 different nationalities, and we speak 28 different languages, including all 6 languages of the United Nations. And our cases, they are also in different languages: English, Spanish, Arabic, Russian, Chinese, Korean, Portuguese, German, all kinds. We are not Hague-centered organization. The Peace Palace, our headquarters, is just a starting point. Actually, we are present on 4 continents. We have 2 offices in Asia, one in Singapore and another in Hanoi, 1 office in Africa, in Mauritius. Hopefully there will be another one. We have 2 offices, well, The Hague and Vienna in Europe, and in Latin America, an office in Buenos Aires. And we travel a lot because our hearings can be organized everywhere. In Riyadh, we have organized already 3 times hearings, if I'm not mistaken. Probably not for the last time, as we like it here, and our parties do so. So we are not limited geographically, linguistically, or culturally. We work through the framework of host country agreements with our contracting parties. Well, last year, 2 of these kind of agreements entered into the force, one with Brazil and another one in Ecuador. Now 2 other are pending internal ratification processes, Colombia and Bahrain. So this framework develops, but we also established very effective cooperation with local arbitration centers, like Saudi Center for Commercial Arbitration, or we cooperate with international organizations, including UNCITRAL, who is happily celebrating its 60th birthday. So happy birthday to UNCITRAL. Joyeux anniversaire. What does it tell it about our casework? Our services are based on another principle, which is preference should be given to the dispute resolution itself rather than to one or another kind of protocol of procedures. So clearly, and despite we have arbitration in the name, there is no preference, nor for arbitration, nor conciliation, mediation, or fact-finding. Historically speaking, PCA started with fact-finding in arbitration, developing conciliation, mediation, all kinds of sui generis procedures like expert determination, review panels, or claims commissions. Why? Because different parties may have different level of trust in different procedures. And the PCA role is not to teach parties what is better for them. Our role is to offer them a plethora of different legal instruments so that they choose. And this is what we do. Even if we propose arbitration, it can be arbitration based on UNCITRAL rules, PCA rules, or laws of Saudi Arabia. Literally, there is no one arbitration like another. And we go beyond, offering conciliation, mediation, fact-finding, and, in many cases, expert determination. In order not to use more time, I will just repeat. Our founding principle is different parties may have different level of trust in different procedures, and so we are bound to operate different dispute resolution procedures all over the world. Thank you. Thank you, Nigel.
Thank you very much, Secretary General Sepelek, and thank you for the birthday wishes as well. And thank you for wearing that coat in honor of our host country, Austria. So it's much appreciated. Professor Dr. Eigen, you have the floor, please.
Excellencies, ladies and gentlemen, I have to apologize for my voice. Fortunately, I don't have to sing for you tonight, but somebody hit me during the day and I was nearly not able to join you at all. But this would be a great shame because it's so wonderful to celebrate the 60 years of UNCITRAL with you, and it's so wonderful to discuss this very interesting subject which we have heard from the 3 panelists already presented to us. My own approach will be slightly different. It will not be so directly connected to arbitration, but it will be connected very directly to the question of how you are able to deal with cultural differences in governance and legal systems and how they affect dispute resolution, which is the name of this panel. In particular, I'm very interested in building trust among cultures. And I think this has been at the heart of the work which I have been doing the last 30 years when I set up Transparency International, when I tried to deal with corruption. And I think corruption and bribery in international, in particular, situations is probably one of the fields in which the difference of governance and cultures is very, very prominent. Maybe I'm convinced that the issues around bribery and corruption are probably the most controversial and differentiated, and the different cultures and legal systems can be a tremendous obstacle, but one has to approach it, and I am very happy that we have a chance to discuss this today. This was very, very evident for me when we started to set up Transparency International. At that time, quite a number of important and wonderful countries like my own, Germany, UK, France, Japan, and I could name quite a number of others, felt that in the international marketplace, their global players, their companies, their investors, had to be allowed to bribe because everybody else was doing it. Only the United States had, under the wonderful leadership of President Carter, introduced in 1977 the Foreign Corrupt Practices Act, making it a crime under US law to bribe abroad. In most other countries, the foreign bribes would even be deductible and as legitimate business expenses. I must say it's nearly ironical that now it seems to be the other way around, when in the United States the Foreign Corrupt Practices Act has been suspended, while we in these 30 years we have been working as Transparency International, we were able to introduce the ideas of the Foreign Corrupt Practices Act in the global governance system. In fact, last week in Germany, a politician was sentenced to prison because he bribed somebody in Azerbaijan. This was unheard of. In the past, he would have said, yes, of course, if you want to do business in the kitchen, you have to be able to face what is customary there. So it's because of this difference which we had between the values and the rules which the members, for instance, the shareholders of the World Bank represented. I was not allowed by the World Bank to deal in a comprehensive way with corruption. I was the director of the regional office for East Africa in Nairobi at the time, so I saw what was happening, what German companies, British companies, French companies, what they were doing in this country, and they were simply buying the wrong decisions, and thereby preventing these wonderful countries in East Africa from developing. So, I mean, saying this about the World Bank is somewhat shameful, but it took until 1997, and I left the World Bank 1991 in order to go ahead with this idea which the World Bank wouldn't allow me to do. It took 1997 for the World Bank to join the sort of anti-corruption front under the very capable leadership of Jim Wolfenson. In fact, he had invited us to his office in Washington, and in spring 1997, and in the fall 1997, he came out at one of the World Bank membership meetings with this intent to join the anti-corruption front. So how did we deal with this? How do we still deal with these differences in many different national contexts which are affected by our fight against corruption? I think the most important feature, and this is what I would like to focus on, is that we created national chapters. We basically introduced a decentralized governance of Transparency International. So nobody ever said that we in Germany were trying to dictate what is corruption and what is allowed and so on, but we rather have had at the time nearly 130 national chapters all over the world, some of them very big and very powerful. And these chapters were basically organizing our fight in their countries, in their own societies, in their own culture, in their own governance systems, and based on their own response and their own ideas, we had a secretariat in Berlin which would try to assemble these inputs and try to create a global consensus on what would then be the strategy and so on of the World Bank. So this is, in my opinion, a very important issue, that we basically give the main tools of our work to civil society organizations in their own countries. And some of these chapters are powerful. I mean, for instance, in Bangladesh, we have about 13,000 members of our chapter. In Argentina, we have about 6,000. In Germany, we have about 2,000, and so on. In some countries, the chapters are small, and in fact, they are not really very effective, because they have to be careful not to get into the system of punishment through their state. For instance, the Russian chapter is right now operating from Brussels, which is a slight perversion of our idea, but this was simply necessary under the present system in Russia. They used to be a very powerful chapter in our organization, and helped us to introduce a lot of systemic changes after 1989 in many of the countries, formerly on the eastern side. So this reality of national chapters is probably, in our opinion, the most important tool which we use to really have our own people implement in their own societies, with their own value system, their own history, their own culture, their own perspectives, the answers which we then try in Berlin to consolidate in regular meetings, in which the members of the national chapters elect our board, and where we have about 120 staff members in Berlin from all over the world, trying to do this very difficult work of consolidating basically the input they get from the many chapters. So this is one element which I wanted to mention. I wanted to also mention briefly another element of our approach to this. That is that we are aware of the fact that there will be always controversial areas in policy making, and therefore it will be necessary to accommodate different interests. And in that connection, we have developed very strongly during the last 30 years what we call the multi-stakeholder approach, that is bringing together civil society, private sector, and government, and in a sort of permanent discourse. Habermas would call this the democratic discourse, which we then cultivate and apply to very specific situations. Just as an example, we bring together bidders in big projects with the World Bank finances, say $500 million road project or a port project or a school project or a hospital project. And we bring the bidders together into an integrity pact in which these three representatives, these three stakeholders, bring forward their ideas and their perspectives. So I was very interested, Cherry, in your presentation, that you feel you have to see things also from the other side. This is exactly it. In Germany, there's a tendency right now among civil society activists to create objective and neutral representatives of civil society to bring about better governance. While we do the opposite. We try to bring a government which has a very strong interest, a very strong perspective, and a strong way of seeing it. We're bringing in civil society. Some of them are very strong, and it takes them a long time to be honest and respectful and so on. And bring the business community. And this sort of multi-stakeholder approach has been so effective that it became sort of the master plan for creating the Extractive Industry Transparency Initiative, which deals with international mining companies in Africa, Asia, Latin America. And we went even so far when we set that up that we decided that the various gremia which are running EITI will have equal voting power in structuring and organizing their work. And this works extremely well. And we are involved in quite a number of similar things. I was very pleased to see the General Counsel of the African Development Bank here earlier, because we are working now, for instance, in Senegal, in creating multi-stakeholder processes in villages. We have about 20 villages in which we try to create governance and stability, which will encourage decentralized investment in the attempt to give under the program 300 about 600 million people in Africa, some of them some access to electricity. So this is basically the two elements, a multi-stakeholder approach in order to deal with concrete controversies through this discourse which I described. In fact, we are not only doing this internationally, we also do this in Germany. I mean, we have a number in our organization which is called the Berlin Governance Program. We do this in about 10 cities in Germany, where we bring together government, civil society, and private sector, and make them agree on certain longer-term issues where they would otherwise not be able to agree. So this has become sort of the mantra a little bit of our work. And I could talk much more about it, but I think we probably don't have all the time of the world. But I'm very pleased to throw this in, even though this is quite different from you. I mean, I was so pleased to hear so many interesting issues presented by you when you talk about arbitration. And I was a bit afraid that I would surprise you coming from a different field, from fighting corruption and so on, and creating better governance. There are indeed these issues, how you bring together trust, how you bring together joint action in a situation where the participants have different rules, different cultures, different histories, and therefore very often don't find a common approach. So I hope this can be a little learning exercise to put into this wonderful discourse which you put forward. Thank you very much.
Thank you, Dr. Hagen. So I think from my perspective, it's been a really useful set of presentations. We've had an arbitrator and counsel perspective, mediation perspective, an institutional perspective, and also the multi-stakeholder process and approach perspective to the discussion. I'm seeing a series of flashing lights from people signaling that we are running out of time. But I was hoping that just as we had kicked off so well by Ms. Blair, alluding to the fact that she had made some comments and participated in UNCITRAL's 50th anniversary, if she wouldn't mind closing by offering some thoughts on where we will be at with dispute resolution and the building of trust 10 years from now, if she were in a similar situation. So thank you.
Well, I'm delighted to do that. I think that we've seen that actually arbitration, dispute resolution generally, international law generally, is facing challenges, but it is because in the end, its offer of certainty, of party autonomy, its offer of a rules-based order is attractive that there is a real future. And we've seen pressures, but we've also seen the arbitration and the wider international law community respond to those pressures. We've heard about some of them. Transparency. UNCITRAL responded to that, and we see more transparency these days. In relation to participation, once again, actually, UNCITRAL have looked at how do we make participation in disputes more widely, and we have some ideas on that. Some of them are working well, some of them not so well, but we are learning from that. I think we've also seen, in relation to the substantive law, if you like, that treaties need to be developed. They cannot be set in stone, and they need to respond to the changing needs of the 21st century. And again, working groups are looking at that. How do we particularly look at the state's rights to regulate? How do we balance a community interest against individual interests? All of this is very positive. I would think, though, that all of those things are to some extent things that have happened to the arbitration community in general by outside forces. But I'd like to perhaps end with something which I think has actually been caused by us, by counsel, by experts, by arbitrators, and that is the issue of damages in international arbitration. I think one of the things that has become increasingly damaging to international arbitration is the growing concern about the amazing amounts of compensation that some tribunals are awarding, particularly in areas where the investors, for example, have basically not built anything at all, and yet end up with enormous sums of damages. I mean, staggeringly multi-billion-pound figures against often extremely impoverished countries. I mean, just recently, an ICSID tribunal awarded $1 billion award against South Sudan. I mean, good luck in getting $1 billion out of South Sudan. That's 15% of the country's GDP. And I think we need to stop and pause and think, in what universe can it possibly seem to be fair that the impoverished people of South Sudan, who don't have schools, who don't have hospitals, who don't have electricity, should be paying 15% of their GDP to an investor who made a punt on an investment and it went wrong. And I'm glad to say UNCITRAL are also having a working group party in relation to that. But to some extent, the remedy is in our hands as counsel, as arbitrators, as expert witnesses. We can control what the rules are in relation to how we award damages. And we have to break out of our little bubble and think this dispute is purely about the two parties, and pause and think, what is the wider implication of some of these excessive awards? So if my plea and my hope for the future is that in 10 years' time, we see international arbitration, international dispute resolution, which is still governed by party autonomy, which is flexible, which is transparent, which involves wider parties, but which also is seen to be balanced and fair, and as I said before, works for everybody and not simply for those fortunate enough to be one of the parties.
Thank you so much, Ms. Blair. And I think we are unfortunately out of time. So I would like to offer a round of thanks to all of our expert panelists. Thank you very much. And I'd like to thank the interpreters for assisting us in conveying us across languages. And I would like to thank the organizers as well for putting together such an excellent panel of experts. So thank you. That concludes panel 5. Thank you very much.